welcome to our program dealing with what you can fund under your Carl Perkins grant. I'm Bob Ray Sanders, your host for today's program. I have with me today the foremost authority on the federal Carl D. Perkins grants, Mr. Michael Brustein.
Good morning, Bob Ray.
Michael is a founding partner in the Washington, D.C. law firm Brustein and Manesivit, which maintains a nationwide education practice. Michael, thanks for being with us today to give insight and advice on Perkins allowables. Before we get any further into the program, I want to remind everyone to have the resource packet with them. We will refer to it throughout the program, so if you don't have it handy, please stop and print it out before continuing to view. Also, several times during our discussion, we will present a situation that we would like you to stop and think about the questions raised. You can then restart the program, and Michael will discuss the topic. Okay, so let's just jump right in. Michael, what guidance can you offer to folks that have some responsibility for developing a Perkins grant?
Well, Bob Ray, I'm glad that you mentioned the resource packet, because throughout the comments in this program, we're going to be making references to the various documents that each of the viewers have. And these are the critical documents that they need in putting together their local application for a Perkins grant. Let me just briefly go over these. We've provided everybody with a part of the actual Carl D. Perkins statute, Section 134, dealing with putting a local plan together, and Section 135, which sets out what the allowable uses of those funds are. In addition, we have what is called OMB Circular A21, which are the cost principles for education institutions. So all post-secondary institutions listening to this program would need to be very attentive as to what the requirements are in these cost principles.
Now, you don't have to be a lawyer to understand those.
Not at all. Okay. Not at all. Even though there's some technical language, you clearly don't need to be a lawyer. What I do want to point out is OMB Circular A21 applies to education institutions, but the U.S. Education Department has made it clear that the Texas Higher Ed Coordinating Board is subject to a different set of cost principles, and that causes a lot of confusion. So we've also included in the packet a copy of OMB Circular A87. A87 are the cost principles for state governments and local governments. So that would govern the coordinating board. A21 would govern the education institutions. We've also provided some very important sections of what's called the Education Department General Administrative Regulations. Those are codified in one document referring to as EDGAR, but in our packet, we have provided references to Part 80, which are administrative rules which apply to education institutions, Part 76, which are the rules for post-secondary institutions and local education agencies to follow in putting together their plans, as well as Office of Management and Budget Circular A133, which are the audit rules, which we'll discuss later on.
Okay, well, Mike, I mean, that's a lot of stuff, but how does an administrator determine what is allowable?
Well, I think the rule of thumb is that when an administrator sits down to put together an application to the state for Perkins funds or to put together a budget, there are four critical documents. One, you would always start with the statute. What does the statute provide? Often the answer is not in the statute. So sometimes the administrator needs to look at guidance that is put out by the federal agency. And in this case, some of that guidance is informal, and we'll be talking about that today. Sometimes the information is not addressed in the guidance. So the administrator needs then to turn to EDGAR, this red book, the Education Department General Administrative Regulations. And sometimes the answer is not even there. They would need to turn to the OMB circular, the Office of Management and Budget Circular, on what is allowable. So they need, when they sit down to take this task of putting together this plan, this application, this budget, to have all four documents.
So EDGAR is not the sole source?
Not at all.
Okay. Now, as you know, there have been significant reductions in state and local support for CTE here in Texas. So is it permissible to use Perkins funds for those costs previously paid for with non-federal funds? we all know that as those as supplanting. Is that what it's called?
That's correct.
Okay, well, tell me a little bit more about that and why they're called supplanting.
I think it's important to first look at this in a macro sense. The statute itself says that federal funds must supplement but not supplant state and local funds. Essentially, this means that Congress wants the federal Perkins dollars to go on top of but not displace what otherwise would be provided with state resources, local resources for career technical education here in the state of Texas. So the statute reads, any recipient, any college participating in the program must make sure that federal funds are being used to supplement existing resources. The problem is that we are now, not only here in Texas, but actually in 46 of the 50 states, in something of a perfect storm where we're experiencing, as you mentioned, reduction in state support. We're experiencing reduction certainly in local tax revenues. The federal government had provided a stimulus 2 years ago, and those funds are about depleted now, or they need to be obligated by September 30, 2011. And this new Congress, the 112th Congress, is really hell-bent on making sure that every dollar is prudently expended. And it seems that no discretionary programs, including education, will escape without some reduction. So we're seeing reductions likely at the federal level, state level, local level. So the problem is, how does a college administrator put together a budget knowing that there are going to be fewer resources available? My sense is that come July 1, 2011, the cuts here in the state of Texas may result in employees at the college level being paid for with non-federal funds, or career technical education activities that are supported with non-federal funds all being cut. So they're going to face the question, can we continue to operate this activity? Can we pay this salary? Can we pay for this instructional activity, this professional development activity, which this year was paid for with non-federal funds? Can we pay for it next year with federal funds? And that's going to be looked at very carefully as to whether or not it violates the non-supplanting rule.
So what is the best way when we're sitting down trying to figure out, what we're about to do? How do we figure out whether or not it is supplanting?
Well, essentially what's going to happen is that either an auditor, a federal auditor, or a auditor under the circular OMB Circular A133 will look at the records of the college, or program monitors from the state Texas Higher Ed Coordinating Board will come to a college, and they'll look at the journal entries, they'll look at their accounting books, and they'll look at, well, what activities were paid for this year ending June 30 with non-federal funds, and whether any of those activities are being paid for in the ensuing year, next year, beginning on July 1, 2011, with federal funds. So it's a simple comparison. Last year non-federal, this year federal. And when they see that, it's going to raise a presumption, but only a presumption, of unlawful supplanting. Whenever there is a presumption of unlawful supplanting, then the college will have the opportunity to rebut that presumption. And this is where it gets a little bit tricky. The U.S. Education Department and the Office of Vocational Adult Education, which administers the Carl Perkins grant within the U.S. Education Department, has put out guidance. There's a recognition throughout the country that there's going to be perhaps a shift from non-federal to federal funding, and they want to make sure that colleges can rebut this presumption of unlawful supplanting. So they're saying to the colleges, you should have two types of evidence available for the auditors, two types of evidence available for the program monitors from the state. One, there has to be evidence that there was an actual reduction in state support or an actual reduction in local support. Now, how would we manifest this? It could be simply a copy of the appropriation language from the appropriation bill of the Texas legislature. It could be a letter going from the higher ed coordinating board to the colleges indicating that there's going to be a state cut, 5%, 10%, or whatever that cut is, but some evidence showing that the college has less non-federal support than they had in the prior year. The second piece of evidence is the determination that the college makes that because of this reduction in non-federal support, would the college have continued that activity without federal funds? It's a hypothetical question. In other words, without state support or state support at the level that it had been, would we have continued this salary? Would we have continued this professional development? Would we have continued this curriculum? And if the answer is no, we would have had to have cut this because of the reduction in state support, then it would be permissible to use the Perkins funds to pay for that activity. So let me just repeat this. Two types of evidence to rebut supplanting. One, evidence that there was a reduction in support, and two, some proof that in the absence of the federal funds, that activity would have been discontinued. That may have been at a meeting of the college president with his executive cabinet. It could have been a deliberation with faculty, but some evidence that an auditor could look at saying, well, if the federal Perkins grant was not received by the college, this activity would have been cut.
Well, then that sounds pretty clear, but if you're in this gray area and you really don't know what to do, what do you advise people then?
Well, unfortunately, it is a gray area, and it's almost a simple black and white analysis that an auditor would do by saying, well, last year it was paid for with state dollars, this year it's being paid with federal dollars. I'm going to cite the supplanting, but it becomes gray when you're saying, well, do I have the evidence here to be able to show that we can rebut that supplanting presumption? My advice is to be very careful. But if that is the road that the college is going to go down, that they're going to be using Perkins funds to pay for a salary, they're going to use Perkins funds to pay for another activity, make sure that evidence is maintained in a file. Without that evidence, the college clearly would have to repay these dollars back to the state, and the state would have to repay it back to the federal government.
So now here's the first scenario. After it plays, stop the show and think about how you would handle the situation. Then restart, and Michael will discuss it.
Susan is project director for a Carl Perkins grant to provide direction and materials for colleges around the state to market the business management and administration career cluster to high schools and local businesses in their community. Several of her college's marketing students volunteered to help with this grant to gain practical marketing experience. Since Susan can't pay these students from the grant, is it allowable for her to use grant money to give them gift cards and/or awards for their work? Also, can Susan use grant money to purchase promotional items to include in the marketing kits?
Michael, how would you advise Susan?
Well, as we go through each of these scenarios, again, it's important to look back at the analysis I stated at the very opening. Susan would need to look first to the statute and ask the question, does the statute provide an answer to this question? I would always suggest that the administrator look to Section 135. Section 135 of the Perkins statute sets out pretty clearly what the federal funds can be used for. And that's divided into 4 sections. The first section says that Perkins funds must always be used to improve the career technical education program at the college. And improve has a very specific meaning. It does not mean to maintain, to do something that's new, different, revise, bring new technology in. So Susan would always say, am I satisfying that requirement? Is this activity going to improve the delivery of career technical education here at our campus? The second section of Section 135 deals with the mandatory uses of the funds, and there are 9 mandatory uses to the Perkins dollars, and she would want to make sure, well, does this fall under one of the 9 mandatory uses? The 3rd section deals with 20 permissive uses, and the 4th section deals with administrative costs. So if you were to start with the statute, she might read through section 135, sections A, B, C, and D, and then determine it doesn't deal with this specific question that I'm asking about gift cards and promotional items that I would like to use the Perkins funds for. So the next step, again, in the analysis, and we would want to follow this analysis each time, is there specific guidance that the Office of Vocational Adult Education has put out on this? And the answer to that is no. So then we're going to move to the circulars. And I, again, said that Circular A21 deals very specifically with allowable costs for education institutions. And in fact, this Circular A21 does deal directly with that question. So Section J, which are the general provisions for selected items of cost, item number 1 actually deals with advertising and public relations costs. And provided herein in this circular from the OMB, it says that costs of promotional items and memorabilia, including models, gifts, souvenirs, are not allowable and cannot be charged to the federal grant. It is not easy to always come up with the direct answer. But fortunately, in this situation, the circular does deal directly with that. So my advice to Susan is be very, very cautious whenever using federal grant funds, not only Perkins dollars, but any federal grant funds to pay for gift items or promotional items for a particular activity. Can they invest in such promotional items? Yes, but don't use federal funds for it. Use other funds.
Okay, well, now keeping in that same vein, can the funds be used for bus transportation?
Again, each time the administrator is asking you a question or the person writing the application to the state or putting together the budget, it's critically important to go through this analysis. So on the issue of bus transportation, again, start with the statute. Does the statute explicitly deal with that? And not exactly. And I want to, we talk about gray areas.
Right.
Congress, when it wrote this Perkins statute in 2006, added some legislative history, reports that were appended to the actual statute. And it dealt with issues such as transportation, such as, say, bus transportation. And the legislative history is crystal clear. It's unambiguous. It states that where a special population student is in need of supportive services to succeed in the career technical education program, then Perkins funds are allowable for that supportive services. And Congress actually used transportation, child care, as examples or illustrations as to exactly what can be done. I would urge administrators to look at the big picture. Is the overall activity improving the career technical education program? And if the answer to that question is affirmative, then the incidental costs such as transportation, providing child care, providing these types of supportive services may be used for what's called these special populations. And let me just take a second, Bob Ray, on special pops, because the 2006 statute in amending Perkins did change the list of special populations. Economically disadvantaged individuals are special populations. If there is a requirement, if a student needs to get to a campus or to have child care provided to their child and they do not have the resources, but they need that to succeed in the program, Congress has identified the economically disadvantaged as a special pop that can be served. Other special populations would include the disabled, students with limited English proficiency, students pursuing training non-traditional for their sex. The important change in 2006 was the academically disadvantaged. The academically disadvantaged are no longer considered special populations. But economically disadvantaged may also be academically.
Exactly.
And if they need help in transportation, then funds can be used to pay for that transportation.
Okay, well, let's take another one. What about membership in professional organizations?
Again, each time I'm going to ask the viewer to go through the same analysis. Does the statute address this question? Does the guidance address this? Again, the answer is no. So keep on looking. And going ahead back to OMB Circular 821, again, it deals directly with this question. Item number 33 in Section J, memberships and professional activity costs. Costs of the institution's membership in business, technical, and professional organizations are allowable. I want to emphasize it's the institution's membership. If an individual wants to use Perkins funds to pay for membership in what's called the Association for Career Technical Education, a professional organization, that would not be allowed. What is allowed is institutional membership in professional activities, not individual memberships. And it's a very important distinction, and it's an audit issue. Auditors would go in there, they'd find that, and they'd ask for the monies to be paid back.
Okay. Now, it's something that we all use daily, cell phones. Can we pay for those?
It's interesting because we're seeing a shift with regard to cell phones. I want to make a couple of comments regarding cell phones. To the extent that cell phones are necessary to carry out the program, that communications need to be made on cell phones, the statute does address it. So in section, and let me pull the statute, in section 135 of the statute, under the permissible uses, item number 7, it provides for the purchasing of equipment, instructional aids. That has never been questioned. To the extent it is necessary for the career technical education program, it would be permissible to use Perkins funds on purchasing the cell phones and for paying for usage on that cell phones, as long as it benefits the career technical education program. My advice is that in every instance, the college should have very detailed policies and procedures, written policies and procedures governing cell phone use, as to what may be charged to a federal grant, specifically the Perkins grant, in terms of usage of that cell phone, what may be charged to it, and so forth. I do want to just speak anecdotally about a very important audit that surfaced this past year. And my firm is involved in representing post-secondary institutions, local school districts, and states on the defense of audits dealing with federal education funds and Perkins funds. And it took place in the city of Philadelphia, Pennsylvania. The auditors, the federal auditors out of Philadelphia in that region went into the Philadelphia school system and took a look at the way they were using federal funds. And after spending many months, in fact, too many months there, they issued a liability of $136 million. Now, that's $136 million is more than the state of Texas receives in any one year, the entire state, for career technical education.
Right. That's not chump change.
Not at all. But one of the many findings in that audit report dealt with the way the policies and procedures that the Philadelphia School District was using federal funds for cell phones and cell phone usage. They did not question that it could be used, but there were not clear policies and procedures as to what could and could not be charged against the federal grant. Significantly, the auditors also said that Philadelphia was not appropriately inventorying or tagging these cell phones in their inventory system. Philadelphia said, well, we only tag items in excess of $500 in value, and cell phones are not $500 in value. The auditors in this case said, no, we strongly recommend that grantees and subgrantees of grant funds, again, including Perkins, put into their inventory system all items, technological items such as cell phones, digital cameras, MP3 players, iPods, that are pilferable. That was the term that they used, that are pilferable. And essentially saying if the item even costs $50 but has a chance of being stolen, it should be included in the inventory system. And I would urge colleges to reimburse, to clearly take a look at their risk management systems to make sure that if they do have a policy where employees working in the Perkins funds can charge part of the cost to the Perkins grant, that it's part of the inventory system.
Now here's the next scenario, which deals with equipment and computers, certainly a part of many grants.
The Green Energy Grant team has been created and secured their office space. Now they are writing the specs for the needed computers. Once they have picked their computers, they have some other technology questions to answer. Can they use their grant money to purchase the following: equipment leases, service warranties, software?
What would you say about this one, Michael?
Well, Bob Ray, I think it's important to point out that most colleges here in Texas probably use a fair amount of their Perkins funds for all three of these items, for equipment leases, service warranties, and software. So it's important that understand where the authority is to support these expenditures. In fact, if they start at the statute, again, Section 135C does provide explicit language that Perkins funds are available for leasing, purchasing, adapting equipment. It would certainly include all three: equipment leases, service warranties to keep that equipment maintained, as well as software for those computers. So I think that the legislation is clear. A couple of points, though, that we need to reference, going back again to OMB Circular A21 on equipment. It makes clear that the funds may be used to purchase equipment. However, in terms of a lease, the cost of the lease must be reasonable. In other words, the rental cost in no instance could ever exceed what the actual purchase price would be. That would probably be viewed as a violation of the Office Management and Budget Circulars. Because so many schools, both at the secondary and post-secondary level, are investing in technology and equipment, some states, really at the behest of the federal office in Washington, D.C., are asking that ceilings or caps be put into the grant to say no more than 30% or no more than 40% of the Perkins grant be used to pay for equipment for computers, leases, and software and maintenance. And I think that that's the direction that many states are following now.
Well, can instructors accept an honorarium?
Well, this issue on honorariums is also an important one. And in a couple of minutes, we're actually going to talk about how institutions would use Perkins funds to pay for the other big ticket item besides equipment, and that's personnel compensation. And honorariums, in a way, comes under this issue of personnel compensation. My advice is that a college should have very clear written policies and procedures on the payment of honorariums. Can Perkins funds be used to bring someone in to speak to provide professional development and get an honorarium? Yes, they can, if it is necessary for the career technical education program and the cost is reasonable. It's always important. Is the cost reasonable? And folks say, well, what does that mean? Cost is reasonable. The government uses a prudent person test. What would a prudent person do in the comparable situation in terms of paying? Would they pay for too much, maybe $10,000 for an honorarium, which might be viewed as unreasonable, versus paying, say, $1,500? Whatever that amount is, it really needs to be set out again in the college's policies and procedures. But I also want to to capture another important point that's directly related to this on honorariums. Perkins is what's called a state-administered program. That means that the monies go from Washington to Texas. The state-eligible agency is the Texas Education Agency. It enters into an arrangement or a cooperative relationship with the Texas Higher Ed Coordinating Board. And either the Texas Education Agency or the Higher Ed Coordinating Board can set its own priorities and limitations. I see some state agencies saying no federal funds for honorariums. Can they do that? Can states do that? Absolutely. States can be much more restrictive than what the federal law allows, and it's up to the state to make that determination. Can colleges then make their own determinations? Yes. The state might say honorariums are permissible, and a college might adopt the policy and procedure and say, no, we do not want federal grant funds to be used to pay it. So you start at the federal level. It is allowable under federal law, but state law, state policy may bridge that determination, and the college itself can come up with even a more restrictive interpretation.
And as you suggested before, colleges should have some kind of regulations regarding these funds.
Yeah, and let me respond to that, Pabre, as well. When an auditor comes on the college campus, or when a state program monitor comes on the college campus, invariably the first question they ask when they sit down with administrators, where are your policies and procedures? Right. And if you don't have written policies and procedures governing the operation of the federal grants, you really are at risk of misexpending the federal funds.
Okay. Now, may the funds be used to purchase meals?
That is a real gray area that we've got to be real careful on. When we talk about meals, let's talk about first meals for professional development for professional staff versus meals for students participating in the particular career technical education program. So in the instance of a staff member going to a professional meeting for professional development, and it's over the course of a day, the circular is unambiguous. The circular says that the cost of meetings and all costs related to those meetings, including meals, may be charged to the federal grant. So again, if the employee working on the career tech program at the college is at a meeting, it is permissible to use federal funds to pay for that meal. I do a fair amount of work with the state of Florida. Florida has a very strict rule. No federal funds, no state funds may be used to pay for meals, period. And the colleges cannot go around that in the state of Florida. So states clearly can say, we have a policy, we don't want federal funds being used to pick up the cost of meals, but it is important to point out that if that cost is related to a meeting where technical information is being provided to staff, meals are permissible. Students. Can meals be paid for students? In this situation, my advice to colleges, be very careful. That often would result in an audit exception. However, the Office of Vocational Adult Education in the U.S. Education Department has put out some guidance. They put out this guidance in May of 2009. And it dealt with participation, again, of special populations, economically disadvantaged students. That if economically disadvantaged students participating in the CTE program are involved in an instructional activity which is off-campus, off-site, it would be permissible to use the Perkins funds to pay for transportation as well as the cost of meals for those students. That is the only guidance that the Office of Vocational Adult Education has given out to permit the use of federal funds for meals for students.
Good. Now let's go to our third scenario.
Bill is interested in increasing the student involvement in his CTE grant. He would like to develop and financially support a local Skills USA chapter. Can he use Perkins funds to support this kind of student organization activity? If so, what aspects of student organizations may be supported?
Well, Michael, can student organizations be supported by Perkins funds?
And all the issues, Bob Ray, that I'm currently working on related to the Perkins Act, none is more controversial than this issue of using Perkins funds to support student organizations. The statute's clear, and Congress has always wholeheartedly provided the authority for the support of student organizations. Section 135C of the statute provides, in item number 5, funds are available to assist career and technical student organizations. But exactly what does this mean? Last week, the state of Michigan, the Michigan Department of Education, received a program letter, determination letter, from the Office of Vocational Adult Education, which questioned Michigan's use of Perkins funds for the support of students going to national skill competitions. Last year, the state of Florida received a comparable letter. So the policy, and it's important, current policy within the U.S. Education Department is that Perkins funds may not be used for certain aspects related to student organizations. In the guidance that I referenced before that the department put out in May of 2009, the question was asked, may Perkins 4 funds be used to support student transportation to, lodging and meals at technical skill competitions as part of National Career and Technical Student Organization conventions? And they answered no, except in certain limited circumstances as described in the last paragraph of this answer, which I'll get to in a second. The department's longstanding interpretation regarding the types of CTSO costs that may be paid from federal grant funds is that Perkins funds used for the support of student organizations may not be used for lodging, feeding, conveying, or furnishing transportation to conventions or other forms of social assemblage. And then they go on to say in this, however, the funds may be used to pay for lodging, feeding, meals of special populations. That's the exception. I'm fascinated by this policy, and the reason is that in a former life, I was the attorney that wrote this for the U.S. Education Department.
Oh, that's why you know so much about it.
When I was a federal attorney, and the intent was to make sure that the Perkins funds were not used for social purposes. And that's why I said in the regulation I wrote, or other forms of social assemblage. Many aspects of the skill competitions are instructional in nature. Nonetheless, I had a meeting with the folks in the Office of Vocational Adult Education in December of 2010. They invited me in, and this is one of the issues we talked about because I was concerned about the memorandum, that the finding they made in Florida and then the one they made this past January in Michigan, in which they questioned this use of funds. And they're saying our policy is unless a student is a member of a special population, colleges, secondary districts should not use Perkins funds to pay for the transportation, meals, or the hotels for the students at those skill competitions.
Wow. Well, now finally, what guidance can you give colleges to certify how their employees' time is used, their efforts, those employees who are working on these CTE activities? Because they do pay Perkins money to their professionals, right, on campus?
Indeed they do. And again, I think it's probably the largest ticket item that grant funds are used for, is to pay for salaries. There's no question that funds may be used for salaries. The issue is how is it done? And whereas I said the reference to the student organizations was a controversial one, I've got to concede that probably 95% of all audits deal with the failure of the college to appropriately certify personnel compensation. The circular, OMB Circular 821, again, governs compensation of staff at the colleges. OMB Circular 887 governs the compensation of staff at the Higher Ed Coordinating Board and other state agencies. The requirements are very detailed, and therefore I urge administrators to be very attentive to them, particularly because if they don't, monies will need to be paid back. And let me just speak again anecdotally about this. Years ago, I represented an organization, a nonprofit in Austin, Texas. The mayor of Austin, the Chamber of Commerce of Austin, they were very interested in a new federal initiative called School to Work. And they put together a 501c3 foundation to work with the children and the students in the high schools in Austin, as well as Austin Community College, to provide school to work initiatives, very much related to career technical education. Austin applied for federal funding for school to work from two federal agencies, from the Department of Labor and Department of Education. And it received funding from both, approximately $1 million from education, $1 million from labor at the same time. And they brought in an executive director for this organization that had no familiarity with the OMB circulars. They ran the programs very successfully for a period of a year, but after 1 year, the federal auditors from the Dallas regional office called up the folks in Austin and said, we know you've been running this program for a year. Now we're going to come in and audit it. And the executive director, who had been working for Dell Computer, responded, well, what are you going to audit? And they said, well, you received 2 grants, one from labor and one from education. We want to make sure that the folks on the education grant actually worked on the education grant, and the folks from the labor grant actually worked on the labor grant. So we want to look at your effort certifications as to who did what. And this gentleman said, well, what is this based on? And they said, well, it's based on OMB Circular A87 and OMB Circular A21. And he said, well, what's OMB? Which is the beginning of the problem.
It's not funny. Forgive me for laughing,
right.
But I can't believe that.
So they came in and they found that the documentation was not in accord with these circulars, and they asked for all the money back, even though the projects were run quite well. In fact, I think they were some of the best projects under school to work in the country. So the issue is here, it has to be done correctly. What the law requires in summary form is that for administrative staff working at the colleges on federal grants, they must document or certify the effort that they worked on at least monthly, that for the prior month, the month of January of 2011, I worked 50% of my time on the Perkins grant and 50% of my time on other activities. But you would need that contemporaneous documentation. It needs to be done monthly. It needs to be signed by the employee as an attestation that that's what they did for the prior 30 days. And that's the problem. Too often the colleges will budget, well, we're going to need 3 full-time equivalents to carry out this activity. We're going to need 2 to carry out that activity. They budget it, but then they don't provide these monthly certifications that what they budgeted, in fact, did happen. The federal government is not interested in whether or not you budgeted or projected that somebody was going to work on the Perkins program. What they want to know is, did that employee work on the Perkins program? And to do that, you want to make sure that we have these monthly certifications. So when the auditors come on site to the campus, when the program monitors from the coordinating board come on campus, they are going to look at those effort certifications to make sure that they reflect exactly what that employee did each month of the 12-month period.
Man, you've educated me.
Good.
Well, we have reached the end of our program. Michael, thank you so much for being here today and helping us all stay legal with our Perkins grants. On behalf of the Texas Higher Education Coordinating Board, Starlink, and myself, we wish you all the best of luck with your Perkins grants.